So I'm going to introduce Kai. So Kai Harper's the HR director for the city of Oak City. She's been a faithful member of OMHRP from day one. And on occasion, I get calls about unemployment claims, and I've never done an unemployment claim. And so I use you guys as my resource. And one time it was a town close to Kai's. I said, do you know Kai Harper? I bet you she could walk you through this. So she did, and so we got to talking, and she said, I think this would be a good subject matter, and I said, I think it would too. So she offered to do this presentation. I'm really excited about it. And if anybody else has a presentation that they would like to do on an HR issue that is important to your city or something that comes up over and over and over again, let us know. We're happy to let you guys do this. This is kind of what this is all about. So,
Hi. If y'all, while I'm up here doing this, because I've already told Pam and Susie, I practiced last night on my mom on this, and she fell asleep. So, if y'all have questions, or if you have comments, or if you want to share your own experiences that you've had with these, I know as HR you've had plenty of them, or dealt with plenty of them, then please share it, because that's one of the great things about this. We come here, we meet, we learn, we talk, but we find out, oh, I'm not the only one going through that. Other people have been through this too, or are going through this, and I'm going to try what they did, because what I'm doing is not working, or vice versa. So, anyway, what I want to talk about are unemployment claims. And I'm going to try to give you some real world tips on fighting unemployment claims. But first, I'm going to tell you a little bit about the Oklahoma Employment Security Commission, which is responsible for when someone files unemployment, that's who they call to put in their claim, and then they'll send it to the employer and let the employer know. We received this. Right now, the OESC has 14 hearing officers, and half of them are lawyers. So while the burden of proof falls on human resources to prove that this employee does not deserve benefits, half the time we are probably trying to prove that to a lawyer who is used to having the burden of proof. So anyway, in Oklahoma, at any given time, there's approximately 22,000 unemployment claims out there that are waiting to be resolved. OESC usually makes their determination, and only 20% of those are appealed. So that means 80% of all your unemployment claims, the employer gets the notice and they just file it away. They don't try to appeal. They don't try to make a determination. Will this be worth our time and resources to appeal this claim? Do we feel like this person really deserves to have unemployment benefits? And 80%, I mean, that's a lot. But granted, not all claims are worth your time and resources to appeal. Now, if something happens and you need a continuance or a delay, they will hardly ever give it to you. It better be literally, you've heard the statement before, literally someone better be dead for them to give you that continuance or that delay, because they are on a very tight time frame. The United States Department of Labor is who funds unemployment programs. So they set the guidelines for each state to follow for their program. So they are on a very tight schedule and a very tight timeline. They have to have 60% of all their unemployment claims that they have completed within 30 days. And they have to have 80% completed within 45 days. So when you receive that notice of that an employee has filed for unemployment, and it says if you disagree, you have 10 days to notify us that you disagree and you want to appeal. It's not 10 days from when you receive it. It's 10 days from the date that's on that notice. So that really cuts your time down to 6 to 8 days to get all your information together and get it sent to them, whether you're mailing, faxing, or emailing. When I terminate, or when one of my supervisors terminates an employee, I already have kind of a background of what's going on that's leading up to this. Every time an employee is reprimanded, whether it's verbally, orally, they're recounseled or counseled or retrained, whatever, I ask my supervisors document it. Because if it's not documented, it didn't happen. I have that on my desk, and if I need to go talk to a supervisor or eyewitnesses, I have who was involved, I can do that. And I make my own report. With that report, I attach the policy that was violated. I attach our progressive disciplinary policy. I attach the handbook acknowledgement that the employees signed, showing that they received the handbook. They've been told what our policies are. All of that goes with every write-up, every reprimand, everything I get. So that if I know an employee's getting ready to be terminated, I already have all of that together. I've received my notice from unemployment because every employee, I anticipate, they're going to go file for unemployment. Some of them don't, but I'm still ready in case they do. So I received that notice. I go to the fax machine and I fax it to them 3 or 4 times because usually I get the little slip that says fail. But once it's to it, they've got everything they need. But I keep that file on my desk because now my anticipation is that they're going to appeal, so therefore I'm going to have to, the Security Commission's not going to take just my word for it. They want to give the employee a chance to tell their side. So I keep all of that there, so if we have to have a hearing tribunal. I didn't even look at this slide, but that's pretty much the gist of what this slide says. Be prepared, do your homework, have everything ready so that when you receive that notice, you can get it to them as quickly as possible. Now, I've already told you the time frames, the 10 days. When you receive a notice of determination, then that determination is going to say, we received your information, we received all your documentation, we have denied this employee benefits because we've decided that you've already shown they had willful misconduct. Or you're going to receive a notice of determination that says, what you send us isn't enough. We're going to go ahead and give this employee their benefits, and they're starting as of this date, which is back to when they were terminated originally, which maybe 2 months ago. Now you've got everything ready because you're already anticipating that. So you're getting your witnesses together. You sent this to them to say, no, we appeal this determination. We want to hear it. We want the tribunal. Between the time that you send it to them, because as soon as they receive it, if you email it, this is something I've learned recently. If you email it to them, then within 2 days, you'll get an email back from them that they have received your information and your letter of appeal, and they will be getting in touch with you, letting you know when the tribunal will be, with instructions for the tribunal. So now you're waiting for that. So during that time, you're getting your witnesses together. Make sure you have first-hand witnesses, people who witnessed it firsthand. Not people who heard, yeah, I heard he did such and such, or called in late 50 times in a month, or, just whatever. Make sure it's people who actually witnessed it. Your supervisors. If it's safety issues, your safety coordinator. Whoever, witnesses that you know are going to be able to help you determine this was willful misconduct. They did this intentionally. The claims that you don't want to appeal, even though you're justified in terminating, You're not gonna win the appeals is if it's negligence, because, or if it's poor, evaluations, you've gotta show that what led to their termination was because they were doing it willfully. People who call in sick continuously, that's willful. They know they're calling in sick and they know what your attendance policy is, but they still continue to do it and get unexcused absences. That's willful. Now, when you're opposing, it's not good enough, and I just said this, it's not good enough to say, we protest, they don't deserve it. They're lazy. They're bad people. They're negative. They're causing a hostile work environment. Unemployment Commission does not care if they're lazy or if they're negligent or if they're causing a hostile work environment, unless they're doing these things intentionally, like again, calling in sick over and over and over, and you know they're not. What you have to do is when you send your information in, remember I said have your own report. Have in that report what each piece of documentation is. Your witness statement, who this witness is, what they witnessed firsthand. What your policy on this page in the employee handbook, this section, this page, this line. And this is where our policy is at that justifies this termination and shows that this employee did this willfully. The most common basis for an employer to oppose an award of unemployment benefits is misconduct. We had an employee, the City of Oak City participates in the Department of Corrections Public Works program where we have inmates, we have a contract with them, we have inmates come and do work, and our employees are trained by us and by the Department of Corrections on how to supervise these inmates. They are told what to do and what not to do with the inmates. They are told about contraband and what is considered contraband. Well, we had an employee that we terminated because a guard at the work center saw the employee give the inmate cigarettes to take back into the work center with him. While cigarettes are not illegal, they are considered contraband. The employee had been through the training. He had been told, you can't do this. He still did it. Department of Corrections notified us, told us he's no longer allowed to supervise any inmates. We terminated him, and he went and filed for unemployment. Well, we sent in the information, he doesn't deserve this. He appealed. We appealed their decision to go ahead and give him the unemployment, and we won because he intentionally gave the cigarettes to the inmate knowing he was not supposed to. And the information I sent in was the policy, his signature on the training roster showing he had been trained, that he's not allowed to do that, and the documentation from the DOC and our own documentation. We won because it was willful misconduct. To establish misconduct sufficient to deny unemployment benefits, you must demonstrate the employee acted intentionally and deliberately, as opposed to carelessly and negligently. Also, there's this Perry Mason moment. You're on the phone. You've got your witnesses, you're sitting in your office or their office or a conference room or wherever, you're on the phone. The employee's on a phone at their house or in their vehicle, wherever, and the tribunal officer is on the phone at their office at the commission, and it's all conference call. You're not in a courtroom, it's not law and order, you're sitting at a desk and you're giving the tribunal officer the facts. You're asking your witnesses, what happened? Tell me what happened. Try to avoid giving them leading questions like, now, didn't you call this person and didn't you say, just say, when you called so-and-so, what were your words to the employee? And what did the employee say to you? Give the witness a chance to tell the tribunal officer what happened. The employees got their chance to give their side of it. A lot of times it's going to be different than what you're saying and what you've got documented. Fortunately, also, a lot of times, they don't have the documentation that you have been diligent on keeping, that you've made sure your supervisors are diligent on getting to you, which is not always easy, and I know y'all know that. It's not always easy getting your supervisors to document. Don't argue with your witnesses, and don't argue the law with the tribunal officer. Tribunal officer knows the law. Like I said, half of them are lawyers. Your witnesses, if you've got a witness that you think might not agree with you or the approach you're taking, you might not want to have that person in there on the hearing for your witness. You should know this. Like I said, if you do your homework and you prepare for this hearing, you should already know, because you've talked to your witnesses and told them this is the approach we're taking and this is what our position is going to be in this. If at any time while you're prepping them and letting them know this, they have disagreement or they think, well, no, I think we should go this way, you probably don't want to have them in there on the hearing. Because the tribunal officers will pick up on that. And also stick with the facts. Only the facts, not the opinion. Not, like I said, nobody cares if they're lazy, nobody cares if they're a bad person. Stick with the facts that led to the termination. And like most things in HR, your likelihood of success is directly related to the effort you put in preparation. Now, this is not on the slides. This is just something I put together to bring because I was afraid that everybody would be quiet and listen. So I've got some scenarios here that I was going to read to y'all, and if y'all will tell me what you think the determination would be. And these scenarios are taken from real unemployment cases, not just from Oklahoma, but also from Texas, where I live. And then I'll tell you what the actual determination was, what the company decided. These scenarios are, they're not from actual hearings. They're actually scenarios that companies went through and they had to determine, is this going to be worth our time and resources to fight this or to appeal this claim. Like I said, not all claims are worth your time and resources. It's a waste of time and resources. I've had some where I thought, man, they don't deserve it. They don't deserve these benefits, but I cannot prove that what happened was because of what I think it was, an accident. Cannot prove that the employee was texting on their phone when they had the accident. If I could, it'd be in the bag, but I have no witnesses to say. Anyway, here's the first scenario. ABC company has a clear policy on absenteeism. Employees are required to call into work 2 hours before the start of their shift and speak to either a manager or a supervisor if they are unable to come into work. If employees do not follow this procedure, their absences are considered unexcused. ABC company has a progressive absenteeism policy in which employees will go through various stages of discipline as unexcused absences increase, ultimately leading to termination if employees experience 7 unexcused absences within a 12-month period. Jane has not been following ABC Company's policy with regard to unexcused absences. After the first time she left a message saying she was unable to come into work, her supervisor spoke with her and reminded her of the company policy. Her supervisor also explained to Jane that this absence would be considered unexcused. After repeated unexcused absences, Jane was terminated per company policy. So would this be worth You know she's gonna apply for unemployment, you've already anticipated that, you've got all your documentation. Is it worth your time and resources to appeal a decision to award her benefits? Yes. So, because excessive absenteeism is considered willful misconduct when not based on an employee's illness or disability. When Jane files for unemployment, ABC Company should participate in the claim hearing and provide the Unemployment Commission with the records of Jane's unexcused absences. The employer should also provide the Commission with a copy of the company policy and instances when the policy was explained to Jane. Document, document, document. Such as a signed acknowledgement from the employee handbook with this policy issued to Jane. Those acknowledgements are great because even in my orientations, I'll go over everything in the handbook and I'll have them sign. I don't read the handbook to them. I do like I'm doing right here with the PowerPoint and all that fun stuff. But I have them sign that I've gone over that. But then they receive the handbook and they sign a paper saying they've received it. So even if they don't read it, it's available to them to read. So there's no excuse not to know the policy. Scenario 2. ABC Company has experienced a slowdown of widget orders over the last few months. Because of this loss of business, ABC Company can no longer afford to employ all 10 widget makers it has on staff, nor does it have enough work for these widget makers to perform. ABC Company has decided to lay off a widget maker, and John is notified that his employment will be ending due to lack of work. I have no idea what a widget maker is, but
Sounds good.
so he's going to apply for unemployment. Should the employer let it go, or should they appeal it? Let it go. Exactly. That is why it's in place. Like any other program or benefit, it gets abused, but that is why it's in place, to help employees when they suffer a hardship, like losing a job, being laid off, or something that is out of their control. Scenario 3. Sally has been unhappy working for ABC Company for some time. Because of this, she has decided to seek employment elsewhere. Sally receives an offer of unemployment from another employer and submits a letter of resignation to ABC Company. A week after leaving ABC Company, Sally learns that her offer with her new employer has been rescinded. She files for unemployment. What should ABC Company do?
She left of her own free will.
She did. Well, even though it's not misconduct, it was willful. So they just need her letter of resignation and the documentation, their report or whatever that shows she left. If she had stayed till right before she was supposed to start that new job and their job offer was rescinded, she'd still have her job and still be employed there. And she could continue her job hunt. But since she turned in the resignation and she stopped working, that's her fault. Bob is currently going through a divorce and now has child care issues that he did not experience previously. He has asked ABC Company if it would consider reducing his hours from full-time to part-time so that he can care for his children. ABC Company agrees to the reduction in hours. Once Bob begins working the new schedule, he realizes that he cannot afford to work only 20 hours per week. Imagine that. I work full-time and I have a hard time affording it. He files for partial unemployment. Should he get it? Should they fight it, or should he be entitled to it? In mind, he's got child care and he's got children to care for. But at the same time, he needs his hours to work, and you know, he's asked for these hours, but should they prevent him from getting partial unemployment, or
He asked
How
for
would
the
we fight
reduction.
Yeah.
I would fight that because he asked for it. We didn't do it.
Exactly. Fact that he's got a, we've all been parents too, and we've all had to make decisions and find a way, and we always do. We always find a way to make it work. He asked for that reduction in hours. He should not get unemployment. Instead, he should work with his employer and see if there's some way or at some time they can increase his hours instead of, the way I see that scenario is trying to double dip. So, all right, and this is the last one. ABC Company is experiencing a slowdown in sales and would like to temporarily reduce the hours of the sales team from full-time to part-time. When business picks up, it is likely that the sales department's hours will increase back to full-time. This loss of wages causes several members of the sales force to apply for partial unemployment. Should it be fought? No. It's not their fault that their hours have been reduced. However, every employer, when an employee is granted unemployment benefits, you're going to get these quarterly statements where you have to enter in wages or lost wages or how much they made during this time period so that unemployment can determine should they still get benefits. Now, if it's someone applying for partial unemployment, you've got to report those wages too. So if at some point in time sales increase and they can increase the employee's hours back up to full time, you're going to receive a notice if there are any of those employees who never notify unemployment.
No.
We all know it happens. So once you receive that notice, then you can notify. First of all, you've got grounds again to terminate. And second of all, you can notify the unemployment commission, hey, on such and such date, we took them back to full time and benefits and all, and they've been receiving unemployment, double dipping. So, anyway, that's all I've got. Please ask questions or.
Tell the Skype people if they have a question, they can type it in.
Yes, if you have a question on Skype, am I looking at the right camera?
Yeah.
Okay, if you have a question on Skype, type it in the message box, and Matt will tell me what the question is, and I'll try to answer it.
What are some of the interesting ones you all have been through?
Yes.
I have one. Basically, the only one we really got our butts handed to us on. We had to go to an appeal. It was a telephone appeal. And when I was a police officer, when we would go to court, we would go to the DA and we'd kind of run through everything real quick so he knew what was going to happen. Well, we did not do that very well before the telephone hearing. And one of the women she's like the assistant in that department, she started answering the question, and as soon as she started answering, number one, she's a very nice woman. Don't get me wrong, she's a grandmother, she's just really nice. But she has a very harsh voice, she is very direct, and the way she started answering those questions, every answer, I just went, oh my God, oh my God, oh my God. By the time we got done, we're done, and we were done. We got creamed. I mean, because the woman that we were filing against had been taping conversations in the department for since the second week she worked there. I mean, she was setting them up since the very beginning. But just the way she answered the questions and just the way it all worked out, we were done. And we got beat, obviously.
And you do have I've had it where I've prepped the witness. I have prepped them. You can anticipate what questions are going to be asked because you know why this employee was terminated. And if it's a disgruntled employee, you can kind of anticipate how they're going to approach this too, because, and we had one where we're answering questions, and they go to one of my witnesses, and they ask, he was the actual supervisor that did the termination. Why did you terminate this employee? Because they told me to at City Hall. There you go. I have nothing. We're done.
Where do we send the money?
Okay. I mean, that was it. And I had prepped him. I had, here's our documentation, here's your write-up, and, but it was only because we told him to at City Hall. So, yes.
Okay, we do have a question on Skype. It's kind of long, so I might edit it as I read it, but it's from Johnny Lewis. He says, there seems to be no structure at the commission. I've done this many times in one. I handled the same way and lost. I've shown proof that the claimant lied at the hearing, and the commission still allowed benefits. I showed where the employee violated laws and they still got benefits. There seems to be no guidance or standard at the commission. One hearing officer will allow you to question the claimant and rebut statements, and the other one doesn't. I just stick to my original challenge, and the claimant changed their stories and was still allowed benefits. In my experience, I have no idea what they really want. There's probably some truth to that.
There is.
People
Well,
are
there
different.
is. I've had unemployment claims that are so much alike, the only thing different about them are the names of the people mentioned in the claim. But I follow the same. One thing I learned a long time ago about human resources, one of the most important things is consistency. And it still might not always go the way you think it should or the way it's supposed to, but you stay consistent. And like I said, when you receive these notices, you need to have everything ready and in order. And you know what, I call them packets. I call them employee not doing good packets. Because I've got the verbal reprimand, I've got the write-ups, and with each write-up, I've got my own report, kind of summarizing and making sense of my witness statements and my supervisor's documentation, because that's not always real coherent either. But I've got my own report making sense of all that, and I've got the policies attached, and I've got the head of acknowledgement, and it's all there and ready to send. And most of the time, if it's worth my time and resources to appeal, there's no problem. But there are still those times that you're going to get this hearing officer that it doesn't matter, they are going to go for the employee. They are going to, it's just, that's their way of thinking. And like we said a while ago, unemployment benefits are there for a reason. Yes, there are people who abuse them, but for the most part, it's a good program, and these people who actually need it, you can tell, okay, am I getting this application because they're on unemployment and they're just sending out applications? Or is this someone who really wants a job, who's really looking for a job? And the benefits, they're on those benefits because it was not their fault. It was not willful misconduct. So all you can do is be consistent. Do the same thing you do every time. Majority of the time, it is going to go your way if it's worth appealing. But like I said, you're still going to have those few officers that it's not going to matter.
And something we've had that we thought was worth fighting, we would have voluntary resignations, they would just resign. But when it came to the hearing, they said they resigned either for their health or a family member's health reasons, and we lost. Even when it was they just came in and resigned. So we've lost those anytime
Yes.
health was an issue.
Yes.
It doesn't even have to be their health.
Because, and the reason is, even though it's a willful resignation, the that's what the employment commission is gonna look at. I've had those too, and my issue is always, but wait a minute. They quit and they never, I've had several of these, they never came to me one time and explained to me their health issues or what issues are going on, or that there's some kind of issue going on, so I can see, do you qualify for FMLA? Do
Right.
you know, is this something that,
We can work through and resolve
yes,
it.
that we
after
can work
12
through, and
weeks,
you can
come
still
back.
have your job, and if after that 12 weeks is up, if you don't qualify for the leave of absence policy, at least, you know we tried. So, but they still win, you still lose those appeals because of the circumstances surrounding their resignation. And like I said, I've taken that approach where I said, listen, I have no documentation, they have never come and talked to me, their supervisor or anybody, and told us any of these issues are going on. That's why we have FMLA. That's why we have these leave of absence policies. And nothing. So,
I just have a question in the group. What do you do when an employee refuses to sign the employee handbook acknowledgement or a policy acknowledgement? How do you handle that? Yeah, it doesn't work in our city.
Sorry, thought you were gonna work here. See you later.
We have sent them, ours is usually, you get a whole department. We recently, I think a year or two, it's probably been closer to 2 years now, we did our policy. And we had a whole department that had kind of other issues, and because of that said, we're not signing it. Emailed it to them and did a read-receipt. And that way, we still didn't quite get everybody, because you can always click, no, do not send read-receipts. We don't have that proof, but some of those, then I could print that out saying, hey, this is where I sent the copy, this is where they received the copy. And like she said earlier, whether or not they read it, that's on them.
These are FOP members, and they're just being a little disgruntled.
I was about to say, unless
Oh,
they're
yeah.
union.
About something else.
And then,
Yeah. But they're a little disgruntled about something else.
Because
So
they
they're,
don't sign it doesn't mean it doesn't apply to them.
well,
some of them won't sign their
Exactly.
time.
still date and sign that they received it
Because
on
they're
this
protesting
date, and
the time
then
sign.
witness it and have somebody witness
They
that
refuse to
received
sign.
it. Exactly, that's kind of what we do. I didn't know if anybody had a better.
well, and the way I look at it, it's like a written reprimand too. If I give an employee a reprimand and they refuse to sign, okay, you can refuse to sign, and it will be noted here that you refuse to sign. It's still written up, whether you sign it or not. And I'm noting on here, so those acknowledgements too, I can put on there, refuse to sign. Employee received at such and such date, at such and such time, and refuse to sign acknowledgement. And it goes in their file.
Give it to them individually or to like
Yes.
department head?
Individually. And once they got what they wanted, then they signed it
Then they
later,
sign it, of course.
like 3 weeks later.
Yeah.
It's like holding hostage.
So, Johnny had one more question, which I think is a good question.
Johnny's scaring me.
But Johnny's question was, what he's concerned about is that when they win the appeal and they get unemployment benefits, that will hurt him in a wrongful termination case. In most cases, that stuff's not admissible at all.
It is totally separate. If they decide to take litigation against you, that's a totally different thing. The Unemployment Commission, Security Commission is there as a benefit for citizens who lose their job due to unwillful reasons, like a reduction of hours or being laid off, or if you work someplace that's being furloughed, so you need to make up those hours, or that's not your fault, that's out of your control. And that's what these unemployment programs are really for. It's what they're supposed to be for. So, yes.
I have seen over the past few years, people who are just terminated, they quit, not terminated, sorry, quit, apply for unemployment, and some of these people have worked for us for 3 days, and they still apply. I mean, they don't get much, but
Yeah.
Would that be worth our time and effort to go after someone who's literally worked 3 days?
I usually do. And usually it doesn't make it to the hearing, to the phone. the
Right.
phone hearing or anything. I received the note, I'm like, are you kidding me?
Yeah.
Who is this again?
Right, yeah.
You know, and I just write up a letter, send it to them, and the timesheet. So this is how they work. This is all they work. And then they were a no call, no show. And then they came and said, I quit, and that was it. And I've got documentation showing that, and I never hear anything again.
We had one who was a mower, said it was too hot. Apply for unemployment.
I'm pushing 50, I can relate. So,
I will add to the wrongful termination, the only time I've ever seen it used in a litigation case is when it wasn't consistent with what was said later. So Kai's point to, you need to be making your packets,
Documenting.
yeah, and document things, because, then that's a good record
yes,
for,
and like the consistency. If you're in a habit of doing it that way, it comes natural. For me, my biggest challenge are getting my supervisors to document it coherently.
That was my question. How are you doing on that?
I've got 3 kids and a man that was in the Navy. I can nag like nobody.
I wouldn't argue with you. I just
So,
wondered about the
Yes, and they hear me. This is my inside voice, people. So.
One more question. You talked about, when you're going through retraining and training, what are some of the kind of, like, when it comes to like a cashier, if they're making a mistake all the time, that's fairly easy to,
Right.
Send them to Anthony Francisco and have him, talk to them. But when it's more like not showing up to work and things like that, do you see where there's a need to just verbally tell them, hey, you need to show up to work, or actually send them to a class, or
And now
there's not a lot for me.
your progressive disciplinary policy, retraining's in there. That doesn't mean you're necessarily going to use it because, like you said, it's a circumstance.
Right.
Coming to work on time is not
Not a
something
training.
that should be part of
Okay.
your training.
All right.
That would be okay, we're doing a verbal warning and or a verbal reprimand. Now we're gonna write you up. Now, if you're following your progressive disciplinary policy, okay, this is your second write-up. You've been counseled, you've been warned. This is your second write-up. If we meet again, it's probably gonna be a termination. You're letting them know at that point. This has to stop, or you're no longer going to be an employee here. And you just get right with, that's it. And you got the documentation showing you have followed your policy. Like I said, in that not doing good packet, you've got a copy of your progressive disciplinary policy. So now you're showing, look, here's the policy, and we are following it, and we have followed it. So, anything else?